Hey everyone, today we're going to talk about limitation of liability clauses in the context of sale of shares or investment contracts. Now, it is common for indemnity clauses to be given by the seller of shares in share sale or investment contracts. Why? Because when you are buying the shares in the company, or you are buying shares by a percentage of the shares when you're investing in a company, you would naturally want an indemnity so that if anything goes wrong, you can sue the seller personally. You can watch one of my earlier videos on indemnity clauses. So, because indemnity clauses are standard in investment or sale of shares contract, the seller has to protect himself by including a limitation of liability clause to limit his liability in case he gets sued. Now, what is the first thing that should be included in a limitation of liability clause? Well, firstly, de minimis claims. What does this mean? It means that the amount has to be a minimum amount before you can claim under the indemnity clause. It usually reads along the lines of no liability shall arise in respect of any claim unless the amount of the claim exceeds 100,000. That is de minimis, the bottom, minimum. There should also be a de maximis claim clause, which is maximum, your maximum liability to the buyer of the shares. So it will go something along the lines of the aggregate liability of the seller in respect of all claims shall not exceed, you can choose the price paid by the buyer of the company, or you can put a fixed price. For example, the aggregate liability of the seller shall not exceed 1 million. Or you can say the aggregate liability of the seller shall not exceed the price paid for the shares. A third common clause would also provide for time. How long does the liability under the indemnity last? It will sound something like, no claim shall be brought unless notice in writing of such claim has to be given by 1 year after completion, 6 months after completion of the share sale. Other common clauses would also include specific limitations. Specific limitations would include things like if there is legislation not enforced at the time of the contract was signed, but was passed afterwards and takes effect retrospectively, especially relating to tax, then the buyer of the shares cannot claim from the seller. Another specific limitation would be the buyer cannot claim from the seller where the claim arises from any allowance, provision, or reserve made in the accounts that has been given to the buyer. Another common specific limitation would be that the buyer will not be able to claim against the seller if the claim relates to a liability that was only contingent, that means hasn't crystallized yet. Another common specific limitation would be changes in accounting policies of the company after completion date. There would also be clauses relating to disclosure and due diligence. If the matter or thing has been disclosed in the disclosure letter or can be found in the due diligence, you cannot claim against the buyer because the buyer has already read the due diligence report, or the matter or thing has been disclosed to him in the disclosure letter. For example, there is a certain lawsuit, there is a guarantee, or there is a potential claim by a director for unpaid salary. It's been disclosed in the disclosure letter already, so he cannot claim for it. Another common clause would be no double recovery. You can only recover once in respect of any claim. The final common clause in limitation of liability clause would be mitigation of damages. So nothing will exclude the buyer from his duty at law to mitigate his loss. That means if he knows of a claim or a potential claim, he has to take active steps, okay, to prevent losing further money. So that's all I have to say about limitation of liability clauses in the context of sale of business. Thanks for watching this video.